Howdy, and welcome to the White Hat Law Show with Warren Nord, where we cover a mix of current events, politics, and the law. Take it away, Warren.
Hello, and welcome back to White Hat Law. My name is Warren Nord. Today we're going to be talking about patent litigation, particularly patent infringement litigation. And here to talk to me about this is going to be Dr. Kevin Lee, who is the CTO, that's Chief Technical Officer of Luraco Inc., which is in East Arlington. And we also have Tom Lee, who is the CEO of Luraco. And these guys will tell us a little bit more about their business in just a minute. But let's go over patents just for a minute before we delve into the infringement issues. What is a patent? A patent is a piece of paper that the federal government talks about the deal it makes with inventors. If you're an inventor and you invent something that's novel and obvious, it's never been done before, and you describe it well enough so that anybody who does that kind of thing can build it, then you can apply for a patent with the federal government. The federal government says, if you'll tell us what you're doing, then we'll give you a monopoly on that for the next 20 years. And by the way, before I get too far, none of this is anything but an overview and introduction. It's not legal advice. Everything that I say, you should hear the word generally speaking somewhere in there, or except in your case in there somewhere. It's not legal advice. So don't say, Warren said this always happens, because that's not what Warren meant to say, even if he actually says that. So where was I? The deal here, though, is that the government does not actually enforce this monopoly for you. You have to sue people to stop them from taking your invention and using it and selling it. And you may say, well, I've gotten a cease and desist letter from some attorney and I'm not making anything that's patented. I'm just reselling something. Well, if you resell something that's patented, or you're selling something that's a knockoff, then you're also guilty of patent. You may also be guilty of patent infringement. It's whoever makes or sells or is involved in helping with the sale of a patented product is going to be a target for patent infringement. So generally, if you make or sell things, you want to make sure that you either have the patent or you ensure that nobody else has a patent on the gizmo you're selling. So you can do a patentability or a freedom to operate analysis. You go to an attorney and say, hey, I'm building this thing. Is it okay? Am I infringing somebody? And they will give you a freedom to operate letter. Or if you want to get a patent, then you go to an attorney and say, would you do a patentability opinion for me? And if you don't find anything, then you go ahead and apply for the patent and build it. So all these things are always easier and less expensive if you talk to an attorney on the front end rather than if you wait until you're being sued. And I'll also say here, if you get a cease and desist letter or any letter from an attorney, you really ought to go see an attorney. You should not wait until a month and a half has passed. Again, I'll say it probably twice more. We are so much cheaper on the front end. Come see us when you first get the letter, and don't wait around. And don't look for just anybody in the world. Do not go to the nearest advertising. Do not just type into the internet, patent attorney. The world is full of people that you know. And you can ask them, do you know of a decent attorney who handles intellectual property or patents? And they'll tell you. And so just doing a random search is almost the worst idea ever. So don't do that. All right. So when we come back in a minute, we're going to get into what happened in the case of Luraco versus EcoJet, which started in 2016 and is ending this week. We'll be back in just a minute.
Whoa, hang on to your hat, folks. More with Warren Nord when we get back. Y'all are back here listening to the White Hat Law Show. Warren, who do we have up next?
All right, welcome back. Okay, so now we're going to talk about Luraco. We have Tom and Kevin here. Somebody tell us about Luraco, its beginning, and what it does.
In 2005, we found Luraco Technologies. And first we plan to develop high technology for military and government. We submit research proposal to military and government and get the funding from them to research and develop high technology product for U.S. military and government. And one of our product, for just quick example, is we research and develop intelligent multi-sensor for Black Hawk and Apache. engine.
Black Hawk and Apache helicopter.
Engine, yes, that is one. And start in 2008, 2007, 2008, we involved into the beauty industry. We developed a chemical film extractor for nail salon. And about 2007, end of 2007, beginning of 2008, we developed magnetic water pump, or magnetic spa pump for nail industry that allows salon owner to use with a disposable liner.
Oh yeah, people need to understand why this is important.
You're
Okay,
right.
so show us one of the older, Kevin, show us one of the older pumps that didn't have this kind of construction.
Before our invention, these are the pump that the industry was using. This is one of the pipeless pump. So this one, it uses a motor and impeller chamber to produce the water jet out.
You guys all know this stuff really well, but the people that are watching don't recognize this. Back when I was a kid, back in the 70s and 80s, before you guys came around, and before the development of this type of motor, we had one drain in a spa, and the drain would go to a pump, and that pump would pump all these pipes leading to different holes in a spa.
Mm-hmm.
And then we had these, and so like the one you just had picked up, of course, that's the 70s, right? Isn't that the 70s?
That's called pipeless pump.
Pipeless pumps, and so you have the water coming in on the outside of that,
and
then it gets ejected through there. So now we have a pipeless system, and each pump is self-contained.
Yes.
Right.
And so, but you have to cut a hole in the spa pump, in the spa tub, to install that.
Right. So this is a little bit more advanced than the compared to the pipe system.
Right.
But in 2007 and 2008, we came out with our design using the magnetic coupling. So this is our pump right here. We use the magnetic coupling technology to couple the motor rotation to the impeller inside this head right here, this chamber right here. So using this magnetic technology, first, there's several advantages. First, you can install the motor outside of the tub.
Right.
And that eliminates the water leak into the motor. Right. You don't have to worry about that. Second advantage is, it allows people to put in a liner.
So you could have a plastic liner between that
the
head
and the motor housing right here.
Right. So so you can install that in the spas, either just outside the tub, or you can cut the hole and put it through either way. But if once it's installed, even if you cut the hole and it's installed, that head is poking through, but you can put a plastic liner over it, and you can still put that head on top of it, the impeller on top of it. Take the impeller apart so people can see that.
And so another advantage of this design is that this head is very easy to sanitize. All you need to do is throw this head into a sanitizing solution, and that's it. You're done with. You don't need to go through this and open all these parts and this. How you clean all this, and you all, in addition to that, you have a big chamber right here to to take care.
Cleaning that would be difficult.
Difficult, very difficult to clean. But in our case, with this magnetic coupling design, it's very simple. You either can throw this whole head into the sanitizing solution, or you can take it out, and that's it. Very simple.
So the water comes in. Let's look at the cap there. So the water comes in the middle.
In the middle,
and then it hits that impeller, which is spinning.
Right.
And that impeller is spinning because it's got metal in it that's being turned by the magnet that's on the shaft of the motor.
Right.
That's so cool. Magnets are magic. So, so you guys hit it big with that, right?
Yeah. Yes. Yeah. So we're the first company developed this technology, and for the spa and whirlpool industry, and this made us the leader in the industry for the.
I've always thought that was pretty cool. It's a good story. All right. So you're humming right along, and you're making the progress and developing patents on some of your products. And all of a sudden, you get sued. When was that? What's that start?
Yeah. So for let me go back to this a little bit. For this product that we developed, we currently have 4 patents. 2 design patent and 2 utility patent granted to Luraco already, and we have 5 more utility patents pending. And I think very soon we'll get those patents reviewed by USPTO as well, because we filed that several years ago. And then around March 2016, we got a lawsuit from EcoJet.
EcoJet.
Right.
So, and EcoJet is an assignee of Luxor, right?
Luxor, right. So basically, Luxor has a patent on one of their pumps, which is this one pump right here.
Right.
And this is not a magnetic coupling pump. This is a standard pipeless pump. So they have a patent to claim the wall on the cap right here and the slope in this chamber right here. So
part of it's important to understand, and let's talk about this for a minute. And whenever somebody says you're infringing my patent, you're really not infringing a patent. You're really infringing a claim of a patent. So an individual patent, let's say I'm Henry Ford, and I've actually never looked this up, so I don't know. Let's say I'm Henry Ford and I've got a patent on the modern automobile. I say, so claim 1 would be I claim a self-moving automobile with 4 wheels and an internal combustion engine. Claim 2 is the car of claim 1 with a transmission. Claim 3 is the car of claim 2 with a windshield and a windshield wiper. So these things build on each other quite often, and so you were accused of infringing a few of the claims of the Luxor patent, which had been assigned to EcoJet.
That's
right?
correct.
Okay. And so that was the beginning of a big ride that we're coming to the end of. And so we're going to take a break just for a second. We're going to come back and talk about the rest of that ride.
Oh, okay.
Whoa, hang on to your hat, folks. More with Warren Nord when we get back. Y'all are back here listening to the White Hat Law Show. Warren, who do we have up next?
Welcome back. And now the exciting adventure of EcoJet versus Luraco and its thrilling conclusion. So you were sued in March of 2016. Mm-hmm. And what did you do when you first got the paper? I think I've got it here somewhere. Right here. Lawsuit against you. It's federal. It's a big deal. It's in California. The court's in California. So what did you do?
First thing, we of course, review the lawsuit,
Sure.
paperwork, and then next step is contact our attorney.
Now, did you have an attorney for this kind of work right then?
Not at that time. We have our patent attorneys. We have several patent attorneys who work with Luraco on filing patents and all that, but they don't have a lot of experience in the patent litigation.
Right.
So that's a problem. Mm-hmm. So we talked to our attorney, and they recommended a few patent attorneys, and we also talked to our friends who also suggested some patent litigation attorneys.
Right.
Yes. So and then after that we have to hire make a decision.
So you hired somebody in Dallas.
That's correct.
And then you had to, of course, you have to have somebody who's close to you for most effective representation. And then you had to hire somebody who is local to California. Mm-hmm. So you hired both those organizations. And in case you're wondering, yeah, that's crazy expensive, right? It's very expensive. Patent litigation is crazy expensive. Yes. And that's sad, and there's no real way around it because it's hard. It's federal, and there's lots of things that can go wrong, and so it's a lot of work. And then, I guess, along the way, you decided to make a change, and hollered at me, and so we teamed up again, and that was fun. And then we got another partner, and so we replaced the first set of attorneys with another set of attorneys, and I'd like to say that your newer attorneys were more cost effective, and we won. At the end of the day, we'll spoiler alert, we win. So we had to. Whenever you get sued, of course, you have certain things you got to do. You have to figure out whether you're going to fight jurisdiction. You guys were sued in California. And there was a discussion on whether to fight that, right? Because you guys don't do business in California.
That's right.
And a few sales here and there into a state is not really what matters. And this is one of those places where attorneys will differ. So had I been your attorney at that time, I would have fought jurisdiction there. But your attorney at the time decided that was not the best thing to do. And this is one of those places where people will say, well, there's a best answer. Some people have different views on things, right? And so it doesn't mean one side was wrong. And as it turned out, we won. So it's hard to say that that was wrong. But usually it's easier and cheaper to be sued where you live.
Yes.
Because you don't need the other attorney then, right? It's all local.
Right.
And then you file your answer, and of course your answer can include a number of things. And your original answer did include a number of things, including what's called promissory prosecution estoppel. Prosecution estoppel. Prosecution estoppel is what we refer to whenever somebody is going through the patent process, and they make and the examiner says, "Well, I'm not going to give you this claim because of some reason." And then you come back and you say, "Well, no, we have a reason why the examiner is wrong," and you explain your reason. Well, if that's why the examiner lets you have the claim, then you can't come back later during the litigation and say that you were just choking that time, that was not the issue. And that wound up being very important in this case, right? Because, and we'll talk about the elements in just a minute, but what they said during prosecution wound up being what saved us from infringement. And so it's an important thing. The other thing that we talked about a little bit is intervening rights. If you've been building, of course, you guys have been building this promoter for more than 7 years, right?
It's 9 years now.
9 years you've been building this before somebody pops up and says, "Oh, I've got a patent on this." The original patent that originated, or the original patent application was filed in what, 2004?
4 or 5.
2004 or 5.
No, 5 or 6 or something.
Yeah. So it had been going on for several times, and again, we'll talk about patent prosecution another time, but there was a patent application, and there's a continuation, and then there was another continuation, and then there was a grant, and there's a long, torturous path that all of which goes back to 2004 or 5. I think the first patent application, I think, was 2004. So you've been building this for a long time, and so that matters. That matters, and so the courts care about that. You can't go around waiting until the last minute, but you have to show the court that you developed this over a period of time. And then, of course, there's a declaration of non-infringement, which the court eventually grants. Some things people may not recognize is that this is, again, federal court. In state court, it's pretty common for us to change our answers and to add and change the claims being made. In federal court, things are much more difficult. You get one shot usually. Then you have to prove to the court that there's a good reason why you should get another shot at it, at making a change or adding something. And all of that is controlled by a scheduling order, which we had a scheduling order. Scheduling order says this is where you're going to go to court, or when you're going to go to court, when is all the discovery due. And so we had some discovery that had to go back and forth, where we were challenging their patent development and who the inventors were. If you say that you were the inventor and you're the only inventor, and then 10 years later you add and say somebody else was the inventor, then you have a right, may challenge that and say, why was that? So that showed up in this case. We had mediation. Some people swear by mediation, some people hate mediation. I'm much closer to the latter than the former. And of course we were unsuccessful in mediation in this case. But it was a requirement by the court. Some people will say that you have a right in this country to a jury trial and that you shouldn't be forced to mediate. What the courts do is they often say, here's your scheduling order, and if you don't really object to it, then tough, you're mediating. And so most people just mediate rather than fight about it. And then along the way, you had to do the claim construction. And that's where we really when we really got to the meat of this case. Claim construction hearing is a time when both sides write down what they think that the elements of each claim includes. And then we would say that this claim construction should control, and the other side says this claim construction should control. In this case, we had a question about what a wall was, right?
Right.
Show them the wall in the EcoJet motor.
Yeah.
So in every pump, there's a wall element that separates the inlet from the outlet water. So Kevin, show us the wall
So
in the
for
EcoJet.
this pump, their pump, they have a wall right here on the cap to separate inlet, which is in the center, and outlets right here.
So the water comes
Coming
into the
from,
middle,
from
and-
the front,
and then it-
and go out here.
and then the wall
the wall.
separates that, and then when it's all put together, there's an impeller.
Right, the impeller.
So impeller that spins the water, forces it to go back out, right? And so that's pretty clearly a wall.
Right.
That's a
And
raised wall.
Right, and all our pipeless pump before our invention, actually all pump have that wall. You know, there's a wall on the cap right here for this pump. This is also another type of pipeless pump. Right. You see a wall there. And the earlier pump that I showed, you see also there a wall between the inlet and outlet. Outlet right here, here, outlet, inlet, and there's a wall there.
Right, and it looks as though when we looked at this, people always did it this way because they have this big cavity, and they have to separate that out.
Right.
Now you made your cavity much
And
smaller.
our design is very, very optimized because we spend a lot of time to do simulation and to test and to considering all the fluid dynamic and everything. Our design is very optimized, and we make the head very thin and small. So that way, we bring the surface of the cap very close to the impeller, and we eliminate the wall. So that's why you don't see the wall.
You don't need the wall.
We don't need it.
Right.
Right.
So you're still separating the inlet and outlet water, but you're
Right.
using the impeller actually
Right,
to
yeah.
do that. Right.
Right.
So that became the guiding issue, right? And so then during the claim construction, we had to talk about what the wall meant. And of course, the court came back and said that the wall was a dividing structure. And so there's a little more to it than that, but for our purposes, that was the big deal. And we wound up having a 2-day trial. Tom, did you enjoy that trial?
Oh, absolutely.
I did not enjoy that trial.
Oh,
I mean,
my
afterwards,
God.
it's easy, but that
Yeah.
was, it's only high stakes. And, it's a serious issue if you lose. So,
Yeah, first time in my life also, first time in my life.
so
Yeah.
so in Santa Ana, so you're on trial.
Yes.
Not on trial, but your company is.
Yeah.
So take the stand. You raise your right hand and talk about the beginning. We talked about earlier the beginning of the company. How did you feel after the event?
At this moment that of course after the court decision, we're so excited. Over 2 years, 2 months of fighting, and but we learn a lot from this guy. I and Kevin, we learn a lot after all this done. But finally we win the case, so that's really good. And by the way, we want to send a message to our client that during last more than 2 years, a lot of call, a lot of concern, exchange email, phone call, concern about that. But it's finally we win the case, so
it's over.
it's over now.
Well, it's not quite over,
not
but
quite
we're getting there. Okay, so this is where we are. We've received notice from the court this week that it had adopted findings of fact and conclusions of law that supported our side. So the way this works in the real world is that both sides sends their, basically it's what we want the court to say and find, and then the court takes both of our proposed findings of fact and says, I like this, I like this, I like this, I like this, and they blend it together or they adopt one side, but they generally say, I agree with these. And it's really just a way of helping the judge get to the point where he can make it fast. And so he's adopted mostly of what we provided, but he didn't take everything, right? We talked about the wall a lot, but we talked about a slope, and we talked about some other issues as well. the court didn't need to find on the rest of it because it found for us on the wall element. And so that's all the court really talked about was the wall. And so now we have to provide a proposed judgment or that the court's going to sign, and then we'll have, and there's some other things that can happen. They could ask for a motion for new trial. They could ask for an appeal, right? So we may be only halfway through this, but let's just say that it's we've successfully completed the trial, and we have some cleanup to do. And if things go right, then that's the end of this series of suits. So I wanted to bring the guys on and talk about this. This was a heavy lifting case for us. It was an important case for Luraco. It impacted the market. Sometimes you have infringement actions where nobody's really making anything, or it's a troll, where they're not making anything, they're just trying to get money from somebody else. This was two head-to-head competitors having a serious fight about who was going to be able to tell their clients that they were doing the right thing. So it was pretty important, and so we were just real pleased to see that it turned out right. And so I wanted to thank our guests, Tom Lee, Dr. Kevin Lee of Luraco, and thank them for joining us today.
Warren, I want to, thank you for, helping us with this case. And
It was my pleasure. It was my distinct pleasure. And we'll see you next time on White Hat Law.
Well, that's a wrap, folks, and we want to thank you for listening to the White Hat Law Show here with Warren Norrid. To find out more about Warren, check him out at norridlaw.com. See you next time.